Here was a married woman. There was no per se sickness. Anything she did would amount to killing the child.
But you did follow up on the family. Viability is evolving. Don't you think mental health then?
That's not enough.
Today I am in the company of one of the most formidable names that India's judiciary has witnessed.
Hima Kohli, having been appointed a judge of the Supreme Court of India, I will uphold the Constitution and the laws.
None other than Justice Hima Kohli. I also want to reflect on your judgment on prevention of sexual harassment, Aureliano Fernandez.
That was an opportunity, I would say, that came my way. So when you talk of woman and gender, or a woman judge and gender, really speaking, it was a simple case where the person who was accused of sexual harassment approached the Supreme Court challenging the decision of the High Court that had upheld his termination of services. It could have remained in that format, and one only had to decide whether the appeal that he had filed on merits could stand the test of law or not, and leave it at that. And by the way, that was a matter where it did not stand the test of law, and we thought that his rights were compromised at various stages and principles of natural justice had not been followed in his case. The matter was remanded back to the authority, the employer, which is the committee, to reconsider it by giving him an adequate opportunity of representation. Mm-hmm. That was as far as the facts of the case went. But I, at that time, who was authoring the judgment with Brother Justice Bopanna, felt that this has to be taken further. Now, these are things you can do when you're sitting in Supreme Court. You have that power which you can exercise. That was also a background when very many sports persons had come onto the streets and done a lot of dharnas, etc., complaining about absence of such committees, POSH committees or appellate committees. And my experience as the chairperson of a gender sensitization committee in the High Court, is also heading one in the Supreme Court, made me feel that these issues need to be addressed. And I took that opportunity to do it. And that's how those directions were issued and are still being implemented by the successor courts.
Yes, at the moment, there's been an expansive implementation in terms of the SheBox portal also. And they're giving specific time limits to states and everything. And I think that's great. A lot of organizations I've seen are now registering and they are submitting in the government repository.
Deep concern was women from the unorganized sector who don't have a voice. They don't have a union to go to. They're working loosely and fixed timings or part-timers who really don't know their rights. How would they be able to get them implemented if they don't even know where to knock?
I also want to go over one of your other judgments where there was a split verdict on the 26-week abortion petition. Right. I want to read it out actually. And you had said that your judicial conscience did not allow the termination. Of course, you relied on some medical reports that had come in a day later, right, if my understanding is correct, which said that there were viability concerns of the fetus involved. So, firstly, if you could walk us through, ma'am, through the medical evidence that was involved when you were considering this issue, and how did you really weigh your judicial conscience in this case?
So first thing I'd like to clarify is it's not that parties directly come to Supreme Court with such like matters. Ordinarily, they go to the High Court, and as High Court judges, most of us at some stage or the other have handled these matters relating to termination of pregnancy in certain fact backgrounds. And there are considerations that weigh with the court, because up to a particular stage it is permitted in law. Beyond that, there is a relaxation, but for giving that relaxation too, there is a limitation. You can't cut across that. In this case, the person concerned chose to approach the Supreme Court directly. But looking at the way the time was running in this matter, we decided to take it on. And that time it was Justice Nagaratna who was sitting with me, and both of us asked for, and right, we do it all the time, we asked the government hospitals to give a report by sending the party for a checkup. And that's not a single doctor, but it's a committee that's constituted to look into all aspects relating to the woman, the fetus, and all other anxieties. Here was a married woman, and she already had a child from the marriage, And this was not the first pregnancy. There was no per se sickness. The fetus was also not suffering from any such malady that needed termination. There are cases where the fetus is suffering from serious maladies and medical conditions which make the court go that way of allowing the application for termination, even if it's crossed that red line. Here was a case, it was a husband and wife. The woman felt that she was not mentally in a state to carry the pregnancy. Now her anxieties was not enough for us to agree to terminating a pregnancy that late. Therefore, we sent her to a government hospital, a prime hospital of this city, for a report. And the report, when it came, on hindsight, I realized, did not highlight certain factors which ought to have been brought in the first place before us. Looking at the report as it stood in the first round, both Sister Nagratna and I decided that it was a case where termination could be allowed. And it was allowed. But the very next day, the state came back on an application saying that these aspects of the report were needed to be brought before the court, which were not there before us. And that is why my anxiety to ask the state that why is it that the doctors, if they knew that this was a position, did not make it clear to the court. At that stage, we would have given it a second thought. Woman's right to her own body and freedom of having a pregnancy, carrying a pregnancy or dropping it is one part. But there is an unspoken right of the fetus also. The second report said that the fetus was healthy and there was nothing wrong with the fetus. And the fact that the report also factored in the fact that the woman was now at the stage where anything she did would amount to killing the child in the womb by an order of the court. And now looking at all of that is what made me say that my judicial conscience would not allow me to go that way. And of course, my colleague on the bench felt otherwise. And since it was a split decision and we were running against time, it was sent to back to the Chief Justice, who marked it to himself with two other judges, because it had to be 3 judges then, since we were a two judges bench. And they also then turned down the request of the lady. I did ask the state council later as to what happened to that child, and I hope the child and the mother were fine. I was delighted to learn that not only the child was a healthy baby, a healthy bonny baby, the mother was very happy that she had carried the pregnancy through. And when the state requested the parents that if they would like to give the child away in adoption, they politely declined and wanted to have the child continue in the family. So it became a one big happy family.
I'm aware of that. I'm aware of the fact that you did follow up on the family later and you found out that the baby is prospering. And that is why I already prepared a viable fetus question on this issue. Because the way I see it, viability is evolving with technology when you're looking at fetus. And when we're looking at, did you look at the woman's affidavit at all? Or did you look at the competing interests of the viable fetus?
The starting point had to be the woman's affidavit.
Yes.
Here was a case where we were anxious to interact with the woman. It was her husband who was coming to court and not the woman. And we were keen that we have an interaction with her, because many times one-on-one, face-on-face, it makes a difference. You understand the anxieties. You want to know what is weighing in the mind of a party who's before you. Here it was a husband, not the woman. We did have a virtual interaction too, because that was a time where we thought that she didn't want to come into court for whatever reasons and she wanted to stay away. But we wanted to have that face-on-face, many times to understand nuances that we may have missed through a counsel representing the party, particularly in a sensitive case like that. So the affidavit was not so clear about the anxieties of a woman who chose to keep the pregnancy on till the last stage and came that late.
Don't you think mental health then, because she did say that, I'm mentally not okay and I don't
That's
think
not enough. Let's not forget that there is a statute that governs it.
Yes.
That the law has been enacted which says these are the conditions A, B, C, D which should be kept in mind. See, being mentally unstable or mentally anxious is different from having a medical condition of the mind. a medical condition certified by a doctor that this person is not physically and mentally in a state to bear the child and carry the pregnancy. Here was a married woman. It was not a case of rape or any violation of her body. She had had a child earlier. The same anxieties in the earlier pregnancy did not make her go that way. She had a healthy child from the marriage. This was a third pregnancy. So this was all within her knowledge and that of the family.
Yes.
And they still decided to continue with the pregnancy till that late. Therefore, it was imperative for us to have a committee of experts who would go through everything related to the woman, both mind and body, and give us a fair assessment.
And your order is very straightforward, no rhetoric, and I read it. It was very recent and short, and it's to the point. So I get that point of yours.
Such cases don't give us the opportunity to write lengthy judgments, because we are also conscious of the fact that there is a time that is running against the pregnancy.